In any democracy, the right to protest is absolutely fundamental. But where's the line between a peaceful assembly and a threat to public order? Today, we're diving into a landmark court case that really forced a nation to decide, drawing a sharp line between what the government can control and what it must protect. So let's get right to it. Do you need a permission slip to make your voice heard? To answer that, we're going to look at this fascinating legal battle that pitted citizen groups against the state. It forced the highest court in the land to clarify the rules of engagement for every single protest. All right, here's our game plan. We'll start with the events that actually sparked the whole conflict. Then we'll look at the law and a pretty controversial policy. After that, we'll see what the Supreme Court decided, and finally, what it all means for your rights today. Okay, let's set the scene. Our story kicks off in the fall of 2005. It was a time of really intense political activity in the Philippines, and a series of protests were about to be met with a police response that would trigger a legal firestorm. So, over just a few weeks, multiple peaceful demonstrations in Manila were forcefully broken up. And these weren't just, one-off incidents. Protesters reported being blocked, violently dispersed, and in a lot of cases, injured and arrested. This tension was escalating, and it really set the stage for a major constitutional challenge. And right here is the heart of the conflict. On one side, you had a law that had been around for 2 decades, Batas Pambanza 880. And on the other, a brand new government policy announced in just a press release called Calibrated Preemptive Response, or CPR. Now, the protesters didn't just challenge what the police were doing on the streets. Nope, they took the fight to the courts and went after the law itself, arguing that Batas Pambanza 880 was straight up unconstitutional. So this is the law at the center of everything. BP 880 was enacted way back in 1985, and it said you needed a written permit to hold a rally in a public space. Now, the idea was just to manage the logistics, the time, the place, the manner, not to censor what the protest was actually about. The petitioners, who were a coalition of activist groups, argued that making someone get a permit is an unconstitutional prior restraint, basically stopping speech before it can even happen. They said it gave mayors way too much power to just say no, the whole process was too slow for urgent issues, and that it essentially criminalized a fundamental right. So, while this long-standing law was being challenged, the government went and rolled out a new enforcement strategy with a much more, assertive name. And this is the sentence that changed everything. The government came right out and said that calibrated preemptive response was now replacing the old policy of maximum tolerance. This wasn't a law passed by Congress, mind you. This was a policy announced by the executive branch, and it signaled a much tougher, more proactive approach to any rallies held without a permit. Of course, the government defended its position. First, they argued that BP 880 was a perfectly constitutional way to balance protest rights with public order. And second, they claimed CPR wasn't even a new policy at all. They called it just a catchphrase for enforcing the law, arguing that maximum tolerance had been misinterpreted to mean just do nothing. So with these two powerful forces clashing, the rights of citizens versus the powers of the state, the case landed right in the lap of the Supreme Court. The justices had to untangle the law, the policy, and the Constitution itself. And the court came back with a really interesting split decision. They ruled that the law, BP 800, was constitutional. It was a valid way to regulate the time, place, and manner of a protest. But, and this is a big but, they declared the government's new policy, the calibrated preemptive response, to be completely null and void. And the court didn't just invalidate CPR, they absolutely condemned it with some incredibly powerful language. They called it a darkness that shrouds freedom. They found it was vague, confusing, and pretty much a justification for abuse, with no place in the country's legal system. So, with CPR thrown out and BP 880 upheld, what does this actually mean for you and me? What are the official rules of engagement for a peaceful protest? Well, the court made it crystal clear that the governing principle is and always was maximum tolerance, as defined in the law. This means police have to show the highest degree of restraint. They simply cannot interfere unless an assembly becomes genuinely violent. The ruling also confirmed the specific permit process. You file an application 5 working days ahead of time. The mayor's office has only 2 working days to do something about it. And here's the crucial part. If they don't act in time, the permit is automatically granted. That's right, inaction equals approval. But the Supreme Court didn't stop there. it actually resurrected this powerful and mostly ignored part of the original law, the mandate for every single city to establish what are called freedom parks. Now, this had massive implications. The law requires every city to designate a public park where people can protest anytime without needing a permit. The court found that compliance with this had been, in their words, pathetic and regrettable. So they issued an ultimatum: designate a freedom park within 30 days, or every single public park and plaza in your city will automatically become one. What a game changer! So this landmark case clarifies the rules, it upholds the process, and it ultimately empowers the right to protest. But it does leave us with a critical question to think about. The law allows for regulations to ensure public order, but this case shows just how easily a new policy, or even just a failure to act, can turn that regulation into an unconstitutional restriction. It's a powerful reminder that the line protecting our freedom to assemble has to be watched very, very closely.